I'd like to introduce our next speaker, Mr. Gary Savine, our next presentation. Mr. Savine is an employment lawyer from Chicago. He has practiced employment law at two of Chicago's largest law firms and have served as chief employment counsel at Navistar and Hill-Rom Holdings. Mr. Savine represents both businesses and employees of all levels to resolve a full range of workplace issues through effective counseling, training, and litigation. He brings over 2 decades of expertise working around the globe to solve the thorniest of workplace disputes. 2 decades. Please welcome Mr. Savine and his presentation regarding narcolepsy and workplace accommodations.
Good day, everyone. I'm Gary Savine, and this is a session on narcolepsy and workplace accommodations. Let's set the stage for what we're going to talk about today before I introduce myself further. Those living with narcolepsy face unique workplace challenges. Employers often falsely attribute the symptoms and effects of narcolepsy to laziness or lack of commitment to the job, instead of understanding the condition for what it often is, a legally protected disability that affords those with the condition to specific legal protections. In this session, I will describe those protections, including, most importantly, the right to reasonable workplace accommodations, and I'll offer tips on how those living with narcolepsy and their advocates can best navigate these issues to protect their jobs and enhance their careers. We're going to basically break this segment into 5 sections. We're going to first talk about, or I'm going to give you an overview of an employer's legal duty to accommodate employees' disabilities. And I'm going to give you some legal buzzwords so that you'll understand what they mean if they come up in the process. Then we'll talk about when and how to ask an employer for an accommodation. There's an art to it, and there are some do's and don'ts to the process that will leave you well equipped to understand in advance. We'll talk about the employer's role in what's called the interactive process, which is the legal terminology for the process that an employer and an employee will embark upon to identify an accommodation. We'll then talk about typical accommodations and what you should do as an employee after receiving an accommodation. And we'll talk finally about common employer mistakes and options for responding to them if you are on the receiving end of one of these mistakes. Now, let me be clear. If you've read my bio ahead of this session, you'll know I'm a lawyer. I want to make clear that this session is not legal advice and should not be relied upon as such. I'm going to be addressing general principles for general education to familiarize yourself with your rights. But how these concepts apply in any given particular set of circumstances may vary, as does what the right course of action might be for an individual for enhancing or for advancing his or her rights while mitigating the risk of potential harm. So if you need help for your personal circumstances, I urge you to hire a lawyer. And a couple of excellent resources for this purpose if you're an employee looking for an employer advocate. One is the National Employment Lawyers Association, NELA, and NELA has an excellent search engine for finding an employment lawyer at nela.org. And you might also look in your city or town for employee advocacy groups that provide pro bono legal assistance for disability-related workplace issues. I'm in Chicago. You'll hear a little bit more about me in a moment. And here we have a wonderful organization called Equip for Equality, which handles workplace accommodations for individuals on either a no-cost or low-cost basis. And they are an excellent resource. But be sure to seek legal help for your particular circumstance. Now, let me introduce myself. Let me tell you who I am, and then we'll get into the meat of the presentation. Again, my name is Gary Savine. I'm pleased to be here today and speaking with you. I am an employment lawyer. I've been practicing employment law for approximately 26 years. It's all I do. I'm Detroit-born, but Chicago-based. I am the founder of a boutique labor and employment litigation and counseling law firm in Chicago called Savine Employment Law Limited. And a little bit about us. Our firm has been up and running for about 12 years now. We represent both employers and employees. Now, first and foremost, we represent employers in all aspects of labor and employment law. Our starting point is a preventative approach. We aim to ensure our business clients comply with the law, like the laws that we're going to talk about today, and help them avoid employee disputes. When disputes arise, we look for peaceful paths to resolution that serves the business's short and long-term goals and promotes positive employee relations. On the employee side, we represent employees with an eye toward enhancing their careers. We value every opportunity to help our clients through difficult and stressful work-related transitions, whether it's negotiating and drafting an employment contract, managing a workplace accommodation issue, or navigating a graceful exit from jobs with options intact. We strive to promote fairness and respect for our employee clients and their interests and rights. And we bring to bear our 26 years of business side experience to help set aggressive yet realistic expectations and to bridge differences faster. That's me, and that's the background that I bring to this presentation. Now let's talk about workplace accommodations and get into the meat of the topic. I want to give you a sense for what we're talking about. Now, I said earlier, and as I mentioned, an employer often has a duty to provide reasonable accommodations if and when the employee has a qualifying disability. What does this mean? First of all, let's be clear that this duty to accommodate disabilities, which may trigger and afford you rights for addressing your condition and its impact on your job, these rights may not apply in all circumstances. Depending on the size of the employer and where the employer is located, an employer may have a legal duty to provide reasonable accommodations, or it may not. Now, generally speaking, private sector employers in the United States with 15 or more employees, they are generally covered by the law, the federal law called the Americans with Disabilities Act, the ADA. You'll hear me refer to both the Americans with Disabilities Act from time to time as the ADA. It applies again. An employer has to have 15 or more employees, generally speaking, to trigger coverage. And how that 15 employee count is determined is subject to a strict test. It's not just a snapshot in time. Employers are measured over a period of time. So if you work for a small employer, you may not have you may not be afforded the protections of the Americans with Disabilities Act. However, even some employees of some small employers may still have protections depending on the state they're in or the locality, the municipality in which they work. For instance, here in Chicago, there is the Chicago Human Rights Ordinance. There's also Cook County Human Rights Ordinance, and there is the Illinois Human Rights Act. These are state and local discrimination laws that provide protections similar to the protections afforded under the Americans with Disabilities Act. The key difference between those laws and the ADA is that the threshold for coverage for an employer being covered under these laws is much lower. Across the board, across all three of those laws that I mentioned, it covers employers with as few as one employee. So it's important for you not to lose hope. If you work for a small employer with fewer than 15 employees, you may still be afforded the protections that I'm talking about today, depending on what state or locality you are in. But let's assume that you're covered by the ADA. Let's assume that employer coverage issue isn't an issue, and that that the employer it is in fact covered by disability discrimination law, like the ADA, that imposes obligations to provide reasonable accommodations. Well, what do you, as an individual, what are the criteria that you must meet in order to have these protections? First, you need to be a qualified individual. The ADA does not require employers to provide accommodations to disabled employees who are not qualified to do the job. And a qualified individual is one who can who can perform the essential functions of their position either with or without an accommodation. You also have to be disabled. You have to be considered disabled in order to be protected by this law. And a disability is, there's a legal standard that a disability or a medical condition must meet to qualify as a disability under the law. Specifically, and not to get too jargon focused, it has to be a physical or mental condition that substantially limits a major life activity. Not all conditions meet this standard. Sometimes a condition may meet the standard in one case, but not in another. So it's often hard to draw bright line rules and say, well, everyone who suffers from narcolepsy is disabled. It's a fact-specific, individualized analysis where a court will look to see if your condition, as it manifests in you, substantially limits you in a major life activity. Now, major life activities, that's also a term of art, it's a legal term. We're talking about things like sleeping and concentrating and even working. Those are major life activities, and you can imagine, if you suffer from narcolepsy, that in many, if not most cases, that condition affects those and substantially limits those major life activities. So if you're covered, if you're a qualified individual, meaning that you're qualified to perform the job, the essential functions of the job, with or without an accommodation, you suffer from a disability, you meet that legal standard, and you work for an employer who has enough employees to be covered by a disability discrimination law that affords the right to reasonable accommodations, you may be entitled to a reasonable accommodation. What is a reasonable accommodation? Well, that's the last of two terms of art that I want to mention. A reasonable accommodation is an accommodation that does not create an undue hardship for an employer, and that enables the employee, or it enables you to perform the essential functions of your job. Again, what is a reasonable accommodation? It's going to depend on the circumstances. It's a fact-specific inquiry as to what's reasonable, and it will depend primarily on your position at the company, the size of the company, and the specifics of the accommodation. We're going to get into that in a little bit more detail too. But there's a process that employers are obligated to engage in order to determine the right reasonable accommodation for an employee who needs one or requests one. It's called the interactive process. And you may hear this term mentioned too if you engage your boss or HR in the accommodation process. This interactive process is really just a dialogue. It's a conversation. In the course of identifying a reasonable accommodation or deciding that there is no accommodation that's reasonable, an employer must initiate this interactive process in which it works with you, the employee, to identify potential accommodations. And it's supposed to be a give and take. And you as the employee have an obligation to participate in that interactive process. And we're going to get into what that means too. So just remember, interactive process, two-way street, you must participate. You request an accommodation, you have to have a dialogue, you have to explore options, and to a certain degree you have to provide information about your condition and how it limits you. And again, we'll talk about that in a little bit more. So those are the terms that I want you to be aware of and I want you to remember. Okay? So what is it, when and how should you ask for a reasonable accommodation or accommodation for your narcolepsy? Well, first of all, I would say as soon as you know that it's interfering with or may interfere with your ability to perform the essential functions of your job. You may know this before you even begin working. You may know that you're going to be working a job where it might be hard given the impact on your ability to concentrate or your wakefulness, that you may need some adjustments to the job. You may be asked during the hiring process. This may even come up. You may be asked point blank during the hiring process. Do you expect to require any accommodations to perform the essential functions of your job? If you hear that question, that means it's incumbent upon you to mention if you believe that your condition may interfere with or will interfere with your ability to perform your job, that you need an accommodation, and say yes to trigger that interactive process then. But let's assume that you're shy or reluctant to bring it up, which is natural. What do you do then? If your job begins to suffer, it's important, if you believe that if your job is suffering, or your employer's opinion of your job performance is being negatively impacted by your condition, it's important for you to be clear in explaining yourself that you're unable to do what's required because but by describing the physical or mental limitation caused by your narcolepsy. If you simply tell your employer that you cannot meet the job requirements or do the job, but you don't provide a coherent, legitimate explanation why, you could be terminated without notice and without recourse, because the employer could legitimately say that they had no idea that you had an impairment that qualifies as a disability, because narcolepsy is not obvious. You need to communicate how it impacts you. Only by putting your employer on notice, by being clear about your condition and its impact on your ability to do your job, do you trigger the employer's obligation to explore the possibility of reasonable accommodations. So let's assume that you've done that. Let's assume either during the hiring process you've mentioned that you need an accommodation, that you will require an accommodation to perform the essential functions of your job, or you happen to wait until performance issues arise or other difficulties arise, and you bring it up then. Hopefully you brought it up before the employer's already made the decision to discharge or discipline you. That triggers the interactive process. What does that mean? Let's assume you've said enough. So your employer is going to do a couple of things. They are going to, and it's important, let me step back, it's important for you to understand how this process works, because you'll be armed with the knowledge of what your role is and what your responsibility is to provide additional information. So your employers realize that this has this duty to complete the interactive process to evaluate and decide whether there is a reasonable accommodation available for you. The employer first is entitled to know the nature of your disability. So they're going to likely ask you, they're going to start by focusing first on whether you're disabled. And remember, I said there's this technical standard, that you have an impairment and that it substantially limits you in a major life activity. It's all jargon, but it's a technical standard, and an employer may want to meet with you and gather information to determine whether or not your condition meets that standard. So employers have some discretion under the law to ask for medical information. And in some states may vary in terms of what's permissible, but generally an employer can ask you questions directly, as long as the questions are job related. They probably can ask it of you, and they might ask you to provide a doctor's note or some sort of doctor's certification. And your failure to provide that information could, depending on the circumstances, deny you the reasonable accommodation that you might otherwise be entitled to. That's your side of the interactive process. So they're going to ask you, they might ask you for certification from a licensed treatment provider. They might ask for it in writing. They might ask for you to sign HIPAA forms. They might set a deadline on you for getting this information. And they might, and if they disagree with it, they might even ask you at their expense to get a second opinion from a doctor of their choosing. These are these are all generally within an employer's right to ask of you, and it's generally your obligation. It's your side of the interactive process to provide it. Let's assume that you've gone through that process, you've established that to your employer's satisfaction that you have a disability and that requires accommodation, and they start exploring with you possible accommodations. Let's talk about what the possible accommodations are that we're talking about. Some of the most, I'm going to list some of the most common accommodations, and I want you to understand that these accommodations may not fit your circumstance, but these are the types of accommodations that most employers, or many employers, kind of tick through or check off in their mind when they think about what's an accommodation. They might talk about a leave of absence. They might talk about a reduced or restricted work schedule. They might talk about a change of work location, a change in job duties, or specific equipment or software to help you perform your job better. You have a role here. If you or your doctor feels that there is an accommodation that you think would get you over that hump, help you meet your employer's expectations and perform the essential functions of your job, and help you overcome the limitations or restrictions placed on you by your narcolepsy, it's incumbent upon you to bring it up and to offer it as an idea. It oftentimes carries more weight for your doctor to document it. Consider, though, its reasonableness. Consider that, remember, the standard is it has to be a reasonable accommodation, and what might be reasonable for a large employer that has money, an endless supply of money to fund accommodations, might not be reasonable in the case of a small employer. But understand that it's part of the give and take is exploring ideas and figuring out together what might work. But understand, ultimately, it's the employer's right to determine if it can identify a reasonable accommodation that it feels that it believes works for your job, will enable you to perform your job. It has the right to offer it and insist upon it, even if you think there's something done a different or an alternative accommodation that might work better. Your doctor's opinion might differ from what the employer decides, and that's depending on the circumstances. I'm not saying in every case, but depending on the circumstances, if an employer can establish that the accommodation that it's determined is actually indeed effective, then the employer it would fulfill its obligation simply by offering that to you. So we've gotten far down the path, and we've just got a couple minutes left, so let me wrap up by talking about what happens. Let's assume that the employer provides an accommodation. You're chugging along with that accommodation. What are the mistakes that often arise, and what should you do about it? What mistakes often arise after an employer has issued or provided an accommodation? Well, I would say the biggest mistake is that employers typically make is that they simply forget. Managers change, HR representatives who are involved in the process change, and the institutional knowledge of the accommodation that they provided fades away, and you're left trying to explain why some accommodation is being taken away from you is in fact an accommodation that you're entitled to. That's the common mistake. An employer will forget an accommodation's genesis and come to and may either simply take it away, or they might resent that, not understanding why it's been provided. They may resent that a new supervisor may resent that you're receiving it, and they might view it as some sort of unjustified special treatment. First of all, let me assure you, you have protections. You've exercised what's called legally protected conduct by asking for the accommodation. So it's important for you to speak up for yourself and remind the organization, as leaders change, remind those in charge that this is an accommodation granted to you, and understand that the disability discrimination laws that afford you the right to an accommodation also typically afford the protection, afford you with the protection from retaliation for asserting your right to an accommodation. So if you're punished in some way by speaking up for yourself, let's say you lose your job or some other adverse action is taken against you, you may have right of recourse in that way too. I close with that to give you confidence in the assurance that there are protections in place to not only help you address accommodations or your need for accommodations up front, but also to protect you once the accommodations are put in place so that you can feel safe in speaking up for yourself and advocating for yourself going forward. I'm Gary Savine. I hope this session was informative and useful, and I look forward to your questions. Hi, everyone. I hope that you found that informative. We've already gotten a number of excellent questions, so I'm going to jump in and begin delving into them. First, I want to add something to the accommodations, the examples that I provided during the presentation, because I understand just from observing one of the prior speakers that some questions came up about family medical leave and the disability process. Leaves of absence can be considered a reasonable accommodation as well. And courts vary in terms of the length of a leave of absence that can be considered a reasonable accommodation. But I want you to, those who feel that you may need a leave of absence, a medical leave of some sort in order to address your narcolepsy and its symptoms, that under the right circumstances, that also could be considered a reasonable accommodation. So even those of you who may not be qualified yet for FMLA, let's say you've only worked for your employer for less than a year and you haven't met the tenure and hours requirements to trigger FMLA coverage, a leave of absence may still be possible under the Americans with Disabilities Act, again, depending on the circumstances. So if any of you have additional questions about that as we move along, feel free to throw them my way. So a couple of questions that have come in so far. Do these legal accommodations also apply to federal employees? Excellent question. And the answer is, fortunately, yes. It does apply to federal employees as well. Another question's come in. If you are seeking employment, when is the appropriate time to disclose your narcolepsy diagnosis? So I'll try to expand on something that I spoke a little bit about during the presentation, which is timing is key, timing is important. It's generally best to disclose it at the point in time when you expect that your condition will impair your ability to meet your employer's expectations, specifically, your ability to perform your job. And I kept speaking during my presentation about essential functions of the job, and I know a lot of folks often get hung up on what that means. Try to think more generally than that. If you believe, for purposes of figuring out when's the right time to bring it up, if you believe that, or you begin to realize that your condition and the way it manifests is going to impair your ability to perform your job or meet your employer's expectations, that's the time to bring it up. And that's the time to start exploring possible accommodations with your employer. And that's important because let's kind of think about maybe possibly one of the more common situations with narcolepsy. I find in my practice that several folks who've come to me with narcolepsy have faced discipline under attendance policies because their inability to regulate their wakefulness has caused them to accrue absences and tardies. And if they have if their employer has a no-fault attendance policy or a point system of some sort, they've accrued points and they've been disciplined or even fired. You cannot get an accommodation retroactively to clear discipline as a legal principle, as a legal rule. Maybe you don't want to bring up your condition to your employer after you've been disciplined. You want to nip it in the bud and address this proactively because your employer is entitled to hold you to the same disciplinary standards as others. So in terms of timing, again, bring it up when you begin to, at the point when you realize or begin to understand that your condition is going to affect your ability to perform your job, and certainly bring it up before it interferes with your job or your ability to meet rules and standards and starts triggering discipline. And like I said earlier, you may even be asked point blank, the common question in an in a pre-hire interview, whether you expect to require any reasonable accommodations. At that point, if you've ever experienced difficulties in prior jobs, that's your cue. And like I said, it's an the law provides for or requires employers and employees to have this interactive process, this dialogue to explore possible accommodations. And that obligation to participate in the dialogue on the employer side does not trigger until the employer has reason to know that you have a possible ADA qualifying disability that may require an accommodation. So let's see, another question that's popped up is it the employee's responsibility to explain requested accommodations and disability to their immediate supervisor, or is that HR's responsibility? It's a good question. Let me think of the best way to approach this. I think you need to bring a flexible mind, a flexible mindset to the interactive process. You may be fortunate enough to be working for a sophisticated employer that has its I's dotted and its T's crossed and already understands the law. Has a sophisticated HR department that has a disability accommodations policy in its handbook and has laid out for you what you're supposed to do to trigger the process and even identifies the relevant people involved and what roles they play on the company side. So I think to answer that question for your circumstance, start by looking in your employee handbook, because there's probably, if it's a sophisticated employer that knows what it's doing, they probably have a disability accommodation policy that tells you what to do. And in those situations, more likely than not, you're going to have an HR liaison working with you and your supervisor and helping the supervisor to understand what the employer's obligations are and what an accommodation means. And they probably also will have in many cases, they'll have a defined process for channeling your responses to medical inquiries to shield your supervisor from the nitty-gritty details of your health condition. But if you're not in that sophisticated of a employer, or working for that sophisticated of an employer, and you may need to educate the boss and your supervisor on what it means to accommodate and what your condition is and how it affects your ability to do the job. And in those cases, I want to go back to something I said at the very beginning of the presentation. It's a great, it's very helpful for you to engage either a lawyer to work behind the scenes. Doesn't necessarily have to be out in front and put the employer on its heels and put the employer in a defensive posture. But getting a lawyer to provide you with some background coaching before you have these conversations is great. And also, like I said, there are great employee advocacy groups for disabled workers. Like here in Chicago, Equip for Equality is a fantastic organization that does that for workers. They provide low cost or no cost advocacy and like I said, behind the scenes coaching to help you when you're working with an employer who may not understand these rights and obligations to help you navigate those conversations and to script those conversations so that you feel comfortable and empowered and safe. So hopefully that's helpful in responding to that question. And let's see, another question that's popped up. It reads as follows. The problem with telling your employer about narcolepsy is that most people don't understand it, and there are stigmas attached, such as sleeping on the job or being lazy. How do you work around that, especially during a hiring process? Well, hopefully we've addressed that to a degree in the Q&A that I've already covered. There is a stigma attached to it, and it does make this process scary, and I do not want to minimize it at all. And that's where getting that coaching ahead of time to know what your rights are and to game out, if you will, strategize what the right approach is for your particular employer in communicating it and documenting what you've done so that you've triggered your rights and put yourself in the best position possible to assert protections if you are discriminated against or retaliated against for having made those requests. It's really important because you're dealing with a condition that is not obvious to the naked eye and that does carry stigmas with it. And like I said, because the law can be tricky in terms of whether you're covered or not, it is important to get some coaching before you have these tough conversations. Okay, a couple of additional questions have popped up. How do you prove a disability? And is there a process, or do you just need a doctor's note? This is, again, lay people hate to hear lawyers say it depends on the circumstances, but it does depend on the circumstances what you're going to need to do to prove to your employer that you're entitled to what you say you need. Some employers will set a very low bar, and they won't go through that complex process that I described earlier about it in trying to figure out whether you meet all those technical legal standards of disability. They might have a very liberal policy and treat any medical condition or impairment as qualifying to get over that hurdle and to start the exploration of reasonable accommodations. Hopefully you're in one of those situations, and I'm finding that the longer the ADA has been in effect, the more I see employers getting over that artificial hurdle of trying to figure out and trying to work with the employee to get medical information on whether the employee has a disability or not, and they're just jumping right to the accommodation process. But your employer's willingness to take at face value what you say is your impairment and what you claim is the way it manifests may be impacted by when you say it and how it's already impacted your job. Like someone mentioned before in one of the prior questions, because narcolepsy is not obvious and carries a stigma and leads often to people jumping to the conclusion that you're lazy. If you bring up your condition after your job is you're already suffering in your performance, you may have a harder time with your employer. You may have a higher hurdle to jump over to prove to your employer that your condition is a ADA qualifying disability that requires a reasonable accommodation. Doesn't mean that you're not entitled to the accommodation, but you are you're going to be starting with a few steps back because the employer is already going to be on the defensive and your supervisor may already be frustrated, which is why it's often important to get that coaching early from an advocate or a lawyer before your job is suffering. But how do you prove a disability when you're having the conversation? It will depend on the sophistication of the employer. The employer may just ask you to provide a doctor's note. One of the best ways that I often coach my clients in handling this is before they even have the conversation and bring up their condition to their employer, I have them solicit a copy of their job description. And hopefully the job description is well thought out enough to lay out what the essential functions of the job are. And then I direct the client, go to your doctor and bring your job description with you to the doctor, and have the doctor explain in a write-up, in a doctor's note, how your condition impacts your ability to perform those essential functions that are in that job description. And if you want, you may have the doctor list out some possible accommodations that you believe would help you overcome your inability to perform those functions, so that you have your doctor's sort of name and signature and authority behind the request when you approach your employer. But just be aware, we talked a little bit about this during the presentation, your employer does not necessarily have to award you the accommodation that you've requested. Your employer only, if the employer concludes that you're entitled to a reasonable accommodation, it's only obligated to provide an accommodation that's ineffective. So it could provide to you an accommodation that you don't want, but is effective. And in that sort of a circumstance, it would be meeting its legal obligations. Another question has come in. Could an accommodation be a work from home, especially if you can prove you work better from home? Excellent question, and a very timely question in our age of COVID-19. So historically, and as you can imagine, stating black letter law or a bright line rule when you're talking federal law like the ADA is difficult, because you got 50 states and 50 separate courts and many different courts of appeals all addressing the same questions. As a general rule, at least prior to the pandemic, most courts had ruled that generally speaking, work from home arrangements are not considered reasonable accommodations. And employers are, in many cases, can deny it just on grounds that it's not reasonable to grant someone work from home when the employer is asking or expects attendance at work to be an essential job function. Now, many of us employee advocates like me, we are hopeful that as workplace culture changes, as companies have en masse suddenly discovered that we can actually all work from home, or many of us can work from home just as effectively, if not more so, than on the job, we are hopeful that the tide will turn and that courts will begin ruling in the opposite direction and begin finding that work from home arrangements are reasonable accommodations under a broader range of circumstances. So I would say stay tuned on that. I'm optimistic. I expect that because it's a fact-based analysis and this question of reasonableness, that as attitudes change about working from home, then more courts are likely going to find work from home to be reasonable. Let me see how we're doing on time. We've got a couple more minutes. Okay, the next question. Can they ask during the interview if you might require accommodations, or only after offering you the position? If so, does that open them up to potential claims of hiring discrimination? Excellent question. So let me step back and say that under the Americans with Disabilities Act, there are rules as to when an employer can make medical inquiries, and when during the hiring process an employer can request that you participate or undergo a pre-employment physical, and that generally that right on the employer's part generally triggers only after it's made what's called a conditional offer of employment. And the conditional offer of employment means they've offered you a job conditioned on you meeting some final set of criteria, like you show that you're eligible to work in the United States. and that you pass a background check, and in some circumstances that you pass a pre-employment physical. But that aside, they are entitled to ask you, even on an employment application, are you qualified to perform a job with or without accommodation? Or do you expect to require an accommodation? It is appropriate to ask that question. Let me hop to the next question. If duties are reduced, can an employer reduce your pay after delegating those to another employee? That's going to depend on the circumstances. If your duties are reduced as an accommodation, what that probably means is that they've reduced or delegated what are called non-essential functions of your job. And if it's a non-essential function, it's just something sort of ancillary that they've thrown on your job that anybody can do, and that it doesn't serve the central core purpose of the position for which you were hired. In most cases, they probably can't reduce your pay. If they've reduced your schedule and you were hourly, obviously that may be in their right to reduce your pay. So again, it's going to depend a bit on the circumstances. Next question. Great. Let's see. It says, does the same accommodations apply to college students with narcolepsy? That's a good question. I don't generally represent students, so I may not be able to answer this question off the top of my head. I mean, I generally represent employers and employees and what employees' rights are. So unfortunately, I'm not sure I can answer that question. I do know that students are entitled to certain rights, and the accommodation analysis might be similar, but unfortunately, I don't know the answer to that question off the top of my head. All right, last question. Thank you for the excellent questions that have come in, and I hope that this has been helpful. If an employer uniformly claims undue hardship to all requested accommodations without offering any alternatives, and the employee strongly disagrees that these accommodations would pose an undue hardship, what should the employee do next? Okay, excellent question. Let me just refresh you all. What the term undue hardship, remember, an employer has a duty to provide reasonable accommodations unless the accommodations would impose an undue hardship. And what qualifies as an undue hardship is it's just too costly or burdensome for the employer's operations, and that the threshold for an employer to be able to prove an undue hardship rises the larger the employer is. So obviously a smaller employer that has fewer resources, less money to spend, less ability to delegate, and can sometimes more often be able to prove undue hardship than a larger employer. But there are some employers, ill-willed employers, if you will, who will just take a blanket undue hardship claim. When I advocate or when I counsel employers, I generally tell them that is a really dumb and dangerous approach to take, because you have to prove in every single case, if you're challenged, why in this case was the requested accommodation, why would it have posed an undue hardship? And you've got to prove it. And you've actually, as the employer, the burden is on you to prove that you've done an analysis. And so I usually coach my employer side clients on how to do that analysis, to actually identify possible accommodations and do some sort of financial analysis or staffing analysis to demonstrate what costs it would actually impose and why those costs are too burdensome. If you, however, are on the receiving end of an undue hardship claim as an employee, and you know that this employer is claiming undue hardship across the board, that's the perfect time. That's often depending on the circumstances, a great time to get an advocate into the situation, whether it's a lawyer or a advocacy group like Disability Advocacy Rights Group, or the Equal Employment Opportunity Commission, which is charged with enforcing the law. It might be a good time to get them involved if this undue hardship claim is putting your job at risk or has resulted in a denial of an accommodation that costs you your job. That's the end of our questions. Thank you very much. I hope this was helpful. My pleasure speaking today. Gary Savine, Savine Employment Law in Chicago.